Ernesto Miranda was a bit of a failure in life. A career criminal, his infamy would, unbeknownst to him, lead to his name being tightly associated with the rights of individuals and the U.S. Constitution. Leaving her job as a concession stand worker at Paramount Theater, Lois Ann Jameson would soon, too, enter completely unexpected circumstances. She left the theater, took a quick bus home, and began walking to her door as she usually did. A car was following her. A man exited the car and quickly walked towards her, immediately grabbing her, covering her mouth with his hand, and yanking her into the back seat of the car. Her hands and ankles were tied, and the man put a knife to her throat. "Hi, I'm an incoming law student, so please take everything I say with a hefty grain of salt. In this video, I will go over the infamous Miranda case that led U.S. citizens to have what we call their Miranda Rights. This video is based on Chapter 9 of the book Is Eating People Wrong by Allan Hutchinson, which I cannot recommend enough. Back to the case. Ernesto Arturo Miranda was actively committing an unthinkable crime. He drove Lois Ann to the middle of the desert and raped her at knife point. Dropping her off near her house after the violent assault, he spoke in her direction, "Please pray for me." After telling her family whom she lived with what had just occurred, the police were called. There were very few leads. Lois Ann didn't have much information on her attacker, so at first, the police had trouble finding Miranda. Lois Ann attempted to return to her normal life. At the end of her shift, her brother-in-law, sister, and mother would meet her at the bus stop and assist her on her walk home. On one such occasion, they noticed an old 1953 Packard car close to the bus stop, and Lois Ann exclaimed to her brother-in-law that the car looked eerily similar to the car she had been assaulted in. Her brother-in-law wrote down the license plate number, and it was soon confirmed that such a vehicle indeed belonged to Twyla Hoffman, Miranda's partner he lived with. Moving with quick succession, the police tracked the lead, arrested Miranda, and brought him into the police station. Experienced officers Carol Cooley and Wilfred Young were assigned to the case. A lineup was conducted to attempt to find the perpetrator of the shocking number of rapes that had taken place in the area Lois Ann lived in. Unfortunately, Lois Ann could not identify the assailant from the lineup, only claiming that the attacker looked like all of the Mexican man standing before her. What happens next would have lasting significance on every crime committed, every interrogation, and every police investigation to come. Cooley and Young questioned Miranda for approximately 2 hours. It is unknown whether Miranda confessed to his crimes voluntarily after being interrogated, or whether the officers threatened Miranda to do so, but he confessed to the rape of Lois Ann, other rapes, and acts of robbery. This sounds like a typical confession, albeit a bit too good to be true from the point of view of the investigating officers. So you may be wondering, what's the big deal and why is his name so closely linked to the Constitution and investigations daily? During his hours spent at the police station, Miranda was never advised of his constitutional amendment rights. The Fifth Amendment plainly states he could not be, quote, compelled in any criminal case to be a witness against himself. The Sixth Amendment writes that he was obligated, quote, to have the assistance of counsel for his defense, should he so wish. The defense would later argue that Miranda had been involved with police so frequently that it was actually unnecessary to remind him of his rights. This would evidently not hold up in court. There was, however, a written statement of his rights pre-printed on the paper on which he wrote his written statement and confession, reading, quote, I, Ernest A. Miranda, do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement may be used against me. However, contrary to what this statement reads, he did not have full knowledge of his legal rights. He was assigned a government defense attorney who did not demonstrate enthusiasm for Miranda's case. At the time of the Miranda case, police had been on the receiving end of multiple checks from the Supreme Court. Prior to the decade of the 1960s, it was thought that if dubious tactics got confessions to heinous crimes, so be it. The tactics worked and there was no issue. The court was giving more strength, however, to the constitutional amendments regarding provision of counsel and the right against self-incrimination. Miranda's initial trial occurred at Maricopa County Courthouse and was considered open and shut. His written confession was, by far, the most hefty piece of evidence. It had him fully confessing to the violent sexual assault. He received a unanimous guilty verdict. Miranda appealed the decision based on the grounds that there was justification for reasonable doubt, that a guilty verdict could not be sure. The star piece of evidence in this case, Miranda's written confession, was obtained by dubious and unconstitutional means and should be thrown out in the trial, unable to be considered by the jury. His defense attorney stated, "Was Miranda afforded all the safeguards to his rights provided by the Constitution of the United States and the law and rules of the courts?" The Arizona Appellate Court was not swayed. The jury's verdict was upheld and Miranda was not granted a new trial. Former district attorney and leader of the American Civil Liberties Union, ACLU, Robert J. Corcoran, would stumble across the Miranda case while reading the Pacific Reporter newspaper. Immediately, he realized it was the perfect case to implement the ACLU's mission of expanding criminals' rights. He brought the appeal to the Supreme Court. After multiple lawyers turned down the opportunity to be involved with the case, something each lawyer surely regretted in the years to come, John F. Flynn partnered with Corcoran. Miranda was thrilled someone was supporting him, writing a letter to Robert. Lasting only 3 days in February of 1966, the Miranda v. Arizona appeal involved 58 lawyers from 14 states submitting written briefs and making oral arguments in front of the court. At the crux of the trial, to quote Is Eating People Wrong?, whether law enforcement officials have to advise suspects in custody of their right to remain silent and to obtain an attorney. This had the potential to cause, quote, fundamental change in police methods and ultimately in the trials of criminals like Miranda. On Monday, June 13, 1966, Chief Justice Earl Warren announced the 5-4 decision in favor of Miranda and a new trial was ordered. As Hutchinson writes, "It was hardly a recipe for clarity and confidence." Warren wrote, "The person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during the interrogation, and that, if he is indigent, a lawyer will be appointed to represent him." This was the beginning of a new era of checks on police power and constitutional rights in action. What do you think of this case? Do you think that Miranda should have received a guilty verdict? Do you think he was threatened behind the scenes? Do you think that having Miranda rights is something that is included in the Constitution? Or were the Supreme Court justices overstepping when they stated such? Thanks for watching.